This is the matter of Bulisky versus Smith, PO 2024-000022. Can you hear me, sir?
I certainly can.
Okay, I can hear you as well now. This is the time that is set for a contested order of protection hearing. There was an ex parte hearing held in this matter on the 9th of August. The judge did issue an order of protection for Ms. Bulisky. Mr. Smith subsequently requested this hearing, and that's what we're here today for. We do have some logistical challenges that we're going to have to figure out here. Is there a deputy there with you, sir?
Yes.
Okay, we're going to need some way to exchange documents during this hearing. Do you have an email to which we can send documents for Mr. Smith's review? And
yes, Your Honor, I can provide you my email if you'd like.
Okay, and then we'll also be sending documents to that email for Mr. Smith's review. And then, Mr. Smith, you have some documents in front of you. Are you planning on wanting to enter those into evidence?
Some of these are notes, and one of which is the testimony by Ms. Bulisky, which has got several materially false statements that I'd like to challenge today.
Okay. The point right now is just that if there's anything that you want to present into evidence and have me consider in making my decision, I'm going to need the jail to send those to us before we can proceed.
Well, one of them is actually an issue about how I've been served.
Well, I don't care what they are at this point. I just want to make sure that we have them in the right places where they need them. So I'm going to need copies of anything you plan to present for me, and I'm going to need a copy for the plaintiff. If we could just get those emailed over to us, we'll make the copies and give the copy to the plaintiff. Can you do that for us, Deputy?
Yes, Your Honor.
And then, sir, do you know which ones you want him to send, which ones you want me to look at?
Well, if I can just please address this issue, there's these basic court documents here that say 435 South Main Street on the top of this. I have tried to mail you with 435 South Main Street.
Okay, sir, do you have evidence? Sir, wait a second, I don't think, sir. Sir, stop. Sir, stop talking. Can you hear me talking?
Yes, I can.
When I'm talking, you don't talk, okay? So I can explain this and we can get through it. I don't want to know what those documents are right now. I want you to hand to the deputy any document that you want me to see. That's all I want you to do. I don't want you to say anything about the documents right now. If you've got a document you want to put into evidence, hand it to the deputy.
I believe you already have this document, is the point I'm trying to make, and the document is defaced and has the wrong address at the top.
I'm not going to repeat myself. If you've got something that needs to be sent over here for evidence, give it to it.
Defaced court document.
Was that the only thing you've got? You're sure? You're sure that's the only thing? All right. So you don't have any evidence that you're going to want to present? No paper evidence?
Address the evidence that Ms. Bulisky has said, and I'd like to be able to state the record with some verbal testimony now, please.
Because it's in the file doesn't mean it's in evidence. If you want something put into evidence, give it to the deputy.
This was a letter that I tried to send to you that had some evidence in it.
We're going to leave it at that. I'm going to send it over. I need to exchange emails with the court. I can do that whenever I have your chance.
But it has also been rejected because of the incorrect address.
I can help you out. Your Honor, can I please receive an email for the court so I can send these over?
Sure, and then you're going to send it from the email that we need to send things to, correct?
Yes, Your Honor.
So will they have each other's emails? You want them sent to you or to the court? Which is? Are you ready, Deputy?
Yes, Your Honor.
We're Cam Verde Muni, M-U-N-I, at courts.az.gov. We'll get these documents exchanged and then we'll reconvene. We're at recess.
One more time, Your Honor. Ken Birdie.
Muni, M-U-N-I, like municipal.
Okay.
And that's at courts.az.gov.
Thank you.
And as soon as we get that, we'll be sending you some paperwork, then I'll come back on and make sure everybody's got all the documents. And
Thank
then,
you.
and then we'll start our hearing. Thank you, we're at recess. Okay, we're recalling the matter of Bulisky versus Smith, PO 2024-00022. Looks like we've had a chance to make copies of documents and get all of these things to the parties. Okay, you have yours there, sir? Okay, very well. So now we're ready to proceed.
May I give my oral testimony, please?
Not yet. Not yet. And the first thing I'm going to do is describe to you the procedure that we're going to go through.
Sure.
The court, of course, has to abide by the procedures that are set out under the law. Otherwise, any decision that I make could be contested, and we're not going to have that happen.
Well, can I please address the procedure about giving an erroneous address at the top of the order of protection of 435 South Main Street when your mailing address is clearly 437?
This is, sir, I think I just told you that you were going to have a chance to argue, but this wasn't the time to do it. And I think I explained to you that I was going to control this hearing procedurally, and we were going to proceed it the way that I said. So I need you to keep that in mind before you start trying to argue, okay? I promise I'll give you a chance to present your argument. I'm not going to have you go away today feeling like you have not been heard. I promise you that. All right? All right. Okay, it's my understanding, sir, that what you're looking to do is have this order of protection completely dismissed. You're not looking to have it modified in any way. You want it dismissed, is that correct?
If it can't be dismissed, I mean, at least allow us to have a dialogue to deal with property that's been stolen. At least I get. I mean, to be honest, all of this in the public domain is actually just covering up police corruption within state.
Okay, I'm getting really tired of having you just talk out of turn. I'm going to say this one more time, and I'm going to ask for your understanding, okay? And from here forward, I don't expect to have to give you the same admonitions, okay? You will have a time to testify. I'm getting ready. I'm trying to get to the point where I can explain to you how this is going to work. You need to stop trying to present your case until I tell you it's time. The onus, the burden is on the plaintiff to prove her case more likely than not. In other words, by a preponderance of the evidence. Because she has that burden, she'll go first. So what will happen is she'll present her testimony. After she's presented her testimony, you'll have an opportunity to cross-examine her. Now be careful, because I can tell you're in a hurry to present your case. Cross-examination is a chance for you to ask questions. That's not the time for you to present your case. So you're just going to ask her questions. So who, what, where, when, why, those kinds of things. Don't try to present your case, because I'm going to cut you off every time. Because procedurally, it's not the appropriate time to do it. And once you've done asking her questions, she can expound a little bit on the answers that she gave to your questions, but that's it. She can't go any farther than just expounding on those answers. Once she tells me she's presented her documents and got all the evidence she wants into the court, she'll rest her case. At that point, I'll see whether or not, if I believe everything she said, does she have a case. Okay? If so, we'll move on and give you a chance to present your case. If I find that even if I believe everything that she's presented, she still doesn't have a case, I'll dismiss it right there before you even do anything. Okay? Now, after that part of it, and I make that determination, it'll be your turn, sir. And then I'm going to ask you, okay, tell me what you want me to know. I'm going to caution you again, we're just here on the things that she accused you of doing. If there are other issues between the two of you, you've indicated there may be some property, some things like that. You think the Sedona Police Department is corrupt, so on and so forth. I'm not here to hear about any of that. I'm here on an order of protection. She's made certain allegations. You've had served to you a copy of the allegations she's made, and I'm going to limit testimony to what's in those allegations. That's my job, is determine whether or not more than likely those are true or false. Okay? All right. And Ms. Bulisky, do you understand these things that I'm describing? You were listening, right? I know you're making notes. Okay. Very well. So what we're going to do first is get you sworn in so we can get started taking testimony. I'm going to have you stand up. And are you shackled?
I am.
So you won't be raising your right hand. You can remain seated. Okay. Please raise your right hand. Do you swear or affirm that the testimony that you'll give today in this contested hearing on an order of protection will be true and correct to the best of your knowledge and belief?
I do.
Thank you. Sir?
I do.
Okay, thank you. Are you prepared? Are you ready to go? Ma'am?
Yes.
Okay, very well. Are you ready to go, sir?
I am.
Okay, very well. Ms. Bulisky, you may proceed. What would you like the court to know about this? This is also the time for you to put in your exhibits. So if the written information that you provided that we make copies of, that's not evidence yet. It's not evidence until you give it to the court today and say, I want this to be evidence. And this is going to be the time for you to give the court those things. Do you understand?
I think so.
You think so? Okay, let's see what.
I can't hear Miss Bulisky.
Pardon me?
I can't hear Rachel. The microphone's not coming through.
Thank you.
I think so, yes.
Can you hear her now? Testing, testing, testing.
Can't hear nothing.
Yes,
One
I think
moment.
so.
Speak again, I'm sorry.
Yes, I think so.
Okay, I can hear that now.
You can hear her okay?
Yeah.
If it happens again, let me know and I'll ask her to speak up.
Sure.
Okay, very well. Ma'am, you may proceed.
Okay, so since his initial arrest, he spent so much time slanderizing me, directly harassing me, came right to my house from jail the first time he was released with no police escort, was contacting me and publishing my address online to his friends, telling them to come after me. Yeah, just nonstop, absurd stories, having people, even since the protective order, calling my landlord, calling my previous employers, the city of Sedona, calling me and the police department pedophiles and blood drinkers. They know me better than that, but this is embarrassing to me. It's damaging to my reputation. After he was released the first time, I had PTSD so bad. I was given a scholarship for a mental health treatment program. I stayed there for 4 months. I'm still having some problems with the PTSD and the non-stop harassment he's making. Since the protective order, he's making videos from jail, harassing me and making fake stories yeah, while he was released the first time, he went and assaulted more women. He was served another protective order. Multiple of his victims have contacted me because they have like 4 different websites that are about me and Sedona Police Department being pedophiles, which I'm not, anyway. So yeah, so now I have all these victims surfacing, coming to me, and I mean, it's just non-stop harassment and slander, and him and his friends have a years of reputation of harassing people. And, yeah, because the last time he was released, he came right to my house. Since he's been in jail, he's attempted to contact me multiple times. All of these have been reported to the police, detective. They have been addressed in the, they've been addressed at the conference meetings, pre-trial conference meetings, by the judge multiple times. I think at least 2 or 3, well, there's initial time where he was also trying to contact and harassing the detective and police on the case, as well as me. Then the judge reminded him that the conditions of his release were to not try to contact me, and he just kept trying again. Then he got his cellmate to contact me, and I did think that it was him that were making the calls to me, but I found out when I got the call records from the jail that they were a bunch of people he must be friends with there, because I don't know anyone else in jail. But I guess he was blocked from calling me, so it's these names of these other people, including one person I think is his cellmate, or in his little, his, I don't know what you call it, his floor or whatever, that have been sending me these, like, text messages, I guess. They use it from their jail app, Getting Out, it's called. But anyway, so, yeah, and so, oh, and in the messages from his friend in jail, like, he's like asking me to come pick him up if he gets out, or that's what his roommate or whatever was saying. So anyway, you know that he came right to my house after his release last time. He has multiple victims since. He is nonstop fixated on me. I have a whole, like, multitude of stalkers now. I mean, this case has been going on for 2 years. I got private investigator, it's overwhelming. And at this point, yes, I think that I need this protective order because he shows no regard for court-ordered, no contact orders or anything really.
Okay.
So,
And your plaintiff's Exhibit A, what is that?
so I'm sorry that some of this is kind of disorganized. I was going to ask for a motion to continue, but I figured he would probably deny it, so.
I would have denied it.
Oh, okay. So Exhibit A is police reports of the initial arrest and charges of when he came to my house without police escort, and I called the police.
Do you wish to have it put into evidence?
Yeah. Yes,
Okay,
please.
very well. Sir, do you have any objection to the police report that's been marked as Plaintiff's Exhibit A?
I don't have it in my possession, I can't see it, so I can't say whether I object to it or not. I need to have those.
Don't you have, I thought you had all of her stuff there in front of you.
Don't.
Oh,
This officer's springing into me right now.
Oh, yeah, I asked about it, I thought you said yes, okay.
You know,
I'll give you a minute to look at that, sir.
Thank you. Okay. So a lot of this is actually from the 15.1, if I'm not mistaken, but there are some differences to this.
Sir, right now, again, I'm going to remind you the procedurally, I'm going to control how we go. The question before you right now is whether or not you have any objection to this exhibit being considered by the court, and if you do, state the reason for your objection, please.
I would like to make an objection to the claim of kidnapping, because Rachel is a
Sir, do you object to the court reviewing this document? I know you're going to say that you didn't kidnap anybody, But do you object to me reviewing the document?
Yes, I have an objection to the documents that have been presented to me. Yes.
What is your objection, sir?
My objection is that Rachel is a self-admitted extreme BDSM model, according to Beelzebub, her satanic...
Okay, sir, your objection is overruled. Plaintiff's Exhibit A is admitted. You gave no legal reason why I shouldn't be able to look at it. You're just objecting to its contents. Please continue.
Exhibit B is the phone records and getting out at request that were sent to my email. And
Do you wish to have these submitted into evidence?
yes, sir. Or yes, Your Honor.
Okay, thank you. Do you object to admission of the getting out exchanges?
Yes, I do.
What's your objection, sir?
Christian Donald attacked me and smashed the tablets, and Christian White has tried to say falsely that I tried to smash up the tablets on A300.
Objection overruled. Plaintiff's Exhibit B is admitted. Please continue.
Okay. Exhibit C is messages from Telegram where Adam, in his own words, describes what he did to me the night of the arrest, which are disturbing and yeah, and also of him trying to dox me, giving my address out to these other people, asking them to stalk me, etc.
Do you wish to have this document submitted into evidence?
I do.
Sir, do you object to admission of Plaintiff's Exhibit C?
Yes, I do.
Why?
At the time, Rachel and I were still living together, and thousands of dollars worth of my equipment was still in our trailer that we lived in together that I paid rent on.
Oh, so you're objecting to the content, not that it's not a legal document or that it doesn't actually reflect a conversation between the parties involved?
Can you run the past me again, please?
So you just don't, you're objecting to it because you don't like what it says, not because it's inaccurate in some way?
Well, I think that it is inaccurate because she's trying to say it's her house rather than it's a trailer, and she's trying to say that I don't have property there, and she's overlooking the fact that I paid rent on the property, and she's overlooking the fact that the property was not given back to me at the end of this whole situation has been engineered in such a way to be able to deprive me of thousands of dollars worth of my equipment. Thank you.
I do find that that this is an accurate representation of a discussion, whether or not the facts that are discussed back and forth are true or not. I'm not going to make any kind of a ruling on that. I'm going to give you a chance to cross-examine her on it if you wish. But in the meantime, it's admitted. Ma'am?
Exhibit D is, I wish I had more time, but this is just, so from all this happening and the mental health problems I had and going to Utah for treatment, I lost my job. I was in an inpatient mental health place that didn't really help. Anyway, Exhibit D is just proof that I was there. I just kind of added that today, just because I thought
Do you
it would
wish to have
show,
admitted
like,
into
how
evidence?
I had suffered, and I lost my job while I was there, my insurance. I had a full-time job working at the hospital, not
So, yeah, it sounds to me like that you've submitted this to make the court aware of the effects that Mr. Smith's alleged actions at this point have had on you. Is that
Yes, sir.
correct?
Yes, Your Honor,
Do you want to put into evidence?
I would.
Sir, any objection?
No objection on this particular piece of information.
Okay, thank you. So admitted. Ma'am?
Okay, Exhibit E is other victims that have contacted me and have asked me, this is a lot of stuff they've asked me to send. Some of it is, okay, It's stuff that they've asked me to send to the prosecutor in this case because they've reached out to me because they're scared if he is released from jail, they're scared for their own lives. One of them is including a protective order that was filed while he was in jail. And, yeah, some pictures of victims since where he burned all the skin off the arm while he was out in between the two.
So I want to just ask you a real quick question. These are all things that other people have told you and written about? These are not things that have happened to you in testimony about what's happened to you?
No, but these are things that make me concerned, that make me feel like I need to have a protective order. When he was originally arrested, I didn't realize like the full scope of who he was, what he was doing with and to other people,
Okay,
past history of whatever, and since.
Do you wish to have these put into evidence?
I do.
Very well. Any objections, sir?
Yes, I do have objection because one of these witnesses made several serious false statements against me, and I've already addressed this with Officer Kim, and the other one is Dr. Ariana Love, who's also made several serious false statements with me. And there has been a constructive fraud going on between Ariana Love and Rachel Bulisky, saying that the mark on her arm was caused by electrocution.
Okay, thank you.
Judge, if I can interrupt for just a second, I apologize. Officer Finley from the Coconino County is indicating they need to move the inmate to another room to get him back on Zoom. It'll be like 2 minutes if they can.
Okay. I'll go ahead and make a ruling on this. I am not going to admit Plaintiff's Exhibit E. Although the plaintiff didn't, or excuse me, the defendant didn't state in exact legal language, what he told me was he believes this is hearsay, and that he will not have an opportunity to cross-examine the people that are making the statements. Therefore, I'm not going to allow them in. We need to take a recess. I understand the deputy needs to move you, sir. So they'll let me know when you get moved so we can resume our team meeting, and then we'll reconvene. We're at recess. Calling the matter of Bulisky v. Smith, PO 2024-000022. When we last were here just a few minutes ago, I had just indicated that Plaintiff's Exhibit E would not be admitted into evidence, and it still is Ms. Bulisky's opportunity to testify. She has not rested her testimony yet, so we'll hear from Ms. Bulisky. Ms. Bulisky?
I think it's Bulisky, but not Bulisky, though.
Ms. Bulisky?
Yeah, just that, you know, no regard, you know, no remorse for what happened, no regard for any court order, no contact, conditions of release, continuing to make slanderizing videos from jail to this day, even after given the protective order. I mean, everything's in here. It's all. There's so much more I could have brought in, but you know, a lot of it was. It's just too overwhelming.
Okay, very well. And I am here to consider the allegations that you made prior. I mean, those are the allegations we're here on. So in addition to your testimony, anything that you alleged before will be considered by the court.
Okay. So all of the allegations that I made in my protective order are supported by these documents.
Okay.
Like I went through sentence by sentence and pulled supporting documents for everything that I said in the original.
Okay, okay, I understand.
I ran out of time. I could have got.
Is that it?
Yes, sir.
Okay, very well. You rest your case then. I do find you made a prima facie case that supports the issuance of your order of protection. Okay. Sir, you may ask her some questions at this point.
Cool. Rachel, how are you?
I'm fine.
Cool. You're fine. Great. Well, so you said that you just have PTSD, so that would indicate you're not fine. You just contradicted yourself. Can you explain this contradiction, please?
I didn't think it's an appropriate question for you to ask me how I'm doing. You're supposed to be asking me questions about the case.
Well, that's just about the case. It says here that you're claiming that I'm running a health scam. Would you care to elaborate on that, please?
I have no idea what you're talking about.
It says here on the report that you've said, let's have a look.
Make sure you let us know exactly where you're reading from, otherwise we have no idea.
Yeah, sure. Let's have a look. Where was it?
Running a health scam? Did you say I'm running a health scam?
Claims that we can put in. Contact me, stalk me, gather belongings, false claims.
Where are you reading from?
It's this. It's the report that it says,
Okay.
do not put back or not additional taxes or payment
Okay.
necessary.
And which date?
I think it was on May 22nd. She's mentioned something about me running a health scam.
Oh, I think I know what you're referring to.
And what exactly is your question, sir?
My question is, what do you mean by that I'm running a health scam exactly? What do you mean by that?
That you were offering treatments for your devaccinator, claiming that you were curing AIDS and removing the COVID vaccine from people in an attempt to get them to be electrocuted with a car battery electromagnet.
Okay, next
No.
question.
Next question, if I may, please. Now, my understanding is up until November of 2022, you used to have a golf-sized lump on your right shoulder, didn't you, Rachel?
I still have that tumor. I've had it since I was 18. It's a benign tumor that I still have.
Can we ask you to roll up your shirt and can we have a look at that benign tumour?
Irrelevant. Next question.
I think it's not irrelevant.
Sir, I've ruled.
Okay, next question. You've said that I've made some dangerous false claims, such as claiming that you are a pedophile and you're a blood-drinking Satanist. Now, my understanding is that you are a member of the Ordo Templi Orientis, are you not, Rachel Ann Bulisky?
I was initiated into the OTO. It's similar to a Masonic fraternity.
The answer is yes.
Well, as for one of those rituals, you've admitted that you've performed the Black Gnostic Catholic Mass, have you not? And you've effectively even hosted Black Gnostic Catholic Mass, haven't you, Rachel?
It's not a black mass, first of all. Anyway, this is not relevant to...
It is relevant because you said that I made the false claim.
Wait just a moment. I'm going to help things out here. Now, if he asks you a question and you feel like it's not relevant, you don't tell him it's not relevant. You tell the court it's not relevant, and you do that by saying objection, not relevant. And then I give him a chance to tell me why he thinks it is relevant, and then I'll rule on your objection.
Okay, objection, not relevant.
Okay, she's objected. Why is that relevant, sir?
Well, I think it is relevant because she's claimed that I've made dangerous and false allegations that she's a blood-drinking, pedophile Satanist, whereas there is evidence by out of head of the order, David Schreiber, on the training videos admitting that 2 children must be present at the Black Gnostic Catholic Mass, which Rachel is admitted on camera.
Okay, no.
Excuse me, I must object.
It's relevant. I'm ruling, sir.
Why do child abuse cult members get protection and children don't get protection, sir?
I'm not here to answer questions for you.
Well,
You understand that?
Well,
You're just about done in this court, sir. You're getting real close to just being done. Okay? You need to follow procedurally the rules that I'm very patiently and trying to very kindly laying out for you. I told you what would happen if it was an objection was ruled, and I told you I had to rule on it. Give me a chance to rule on the objection. Do you understand me?
Sure.
All right. Overruled. Next question.
She said that I falsely claimed that she's stolen money from me. Last time I checked, gold was money in every jurisdiction of the world, and she's taken 2 spherical gold-plated
Sir, do
magnets.
you have a question?
Where are my gold-plated magnets, Rachel?
There you go. Where or what?
My 2-inch gold-plated spherical N52 neodymium magnets. Where are they, Rachel? What have you
What
done?
does that have to do with this case, sir?
She's making false claims that I'm falsely claiming that she stole the money from me.
And what does that have to do with where your stuff's at?
Do you operate the account called Trash Riot on eBay, Rachel?
Irrelevant objection.
What's the relevance of whether or not she has an account on that site or not?
She's claiming that I have falsely claimed that she has stolen money from me. She has actually stolen money from me. I can evidence this based on what she has taken from me illegally and stolen and sold on eBay on her Trash Riot account. This objection should be...
The fact that she has an eBay account does nothing to prove that she sold your property on that account.
Sorry, but she has sold a computer...
Her irrelevance objection is sustained. Next question.
Next question. Can you explain to me how Jesus Evangelistic, your detective buddy, can afford a $500,000 Sedona Red Rock News convertible Mercedes on a detective salary, please?
Objection irrelevant.
How is that relevant to the issues that are before the court, sir?
She's trying to gain victim status in order to cover up police corruption, and these are reprisals for exposing police corruption.
Objection sustained. Next question.
Can you explain whether or not Detective Jesus Evangelist has paid tax on his $20,000 per bottle of French cognac?
Objection irrelevant.
How is that relevant to the issues before the court, sir?
Once again, this order of protection is to try to get Rachel Bulisky victim status so that she can bury the fact that she has stolen my property, and she's hiding the fact that she is a member of a child abuse cult and that they are abusing children at the Black Mass Catholic Mass ritual, which she has admitted that she has...
Objection sustained. Next question.
Why are you stating here that I have kidnapped you and I have beaten you, when you are seen on the movie Rabbit the Scream Queen and captive audience being put into bondage, and your boyfriend's satanic porn director Bulisky even calls you...
Sir, do you have a question? This is the time. Sir, you're either incapable or unwilling to understand what I'm telling you. So I'm going to try again. Don't testify. Don't say things about facts that haven't been brought into evidence. You're here at this point in the procedure to ask questions. That means that your sentences should start with who, what, where, why, how, do, and those kinds of things. I promise I'll give you an opportunity to tell me what you think her motive is in this, but this is not the time to do that. You may continue.
Were we living together as of December the 14th, 2022?
Yes.
Were we lovers up until that time?
Yes.
Did I come to that place, day in, day out, freely?
Yes.
Did thousands of dollars worth of my equipment reside in that place?
Well, repeat that.
Did thousands of dollars worth of my electronic equipment reside in that place where I resided with you?
I really doubt that it was worth thousands of dollars, but all of the equipment that you had there, you were given back with police escort, and also given way longer than the police escort is supposed to be 15
Okay,
minutes.
that's good. You've gone beyond answering the question.
All
Next
of-
question, sir.
Do you practice BDSM, bondage, discipline, sadism and masochism?
No, I don't.
Why can I see Rachel Bulisky being tied up in the movie Rabbit the Scream Queen?
Objection irrelevant.
Sustained.
Why can I see Rachel Bulisky being choked out in the movie Captive Audience?
Objection irrelevant.
Sustained.
Do you deny that Rachel Bulisky in Captive Audience being choked out whilst chained up is the same Rachel Bulisky I'm talking to now, you, Rachel?
A horror movie I was in my 1920s, in my 20s, is completely irrelevant to...
Are you objecting?
Objection irrelevant.
How's that relevant, sir?
Well, because I'm being charged with aggravated assault, kidnapping and attempted murder over a consensual BDSM account.
Objection sustained. Next question.
Did you perform COVID testing while you were working in Sedona?
Objection irrelevant.
Sustained.
Next one. Do you have your call logs for July the 7th, 2024?
Say again?
Do you have your call logs on your phone for July the 7th, 2024?
I can't understand.
Call log.
Call lock?
Log. He's
No,
asking
I
if you have a
don't.
call log. The
From-
answer is no.
Are you aware that I was locked up in solitary confinement on A200 on July the 7th, 2024?
No.
Well, can you explain to me how am I able to call you when I'm locked up in my cell on 23 hours solitary confinement, please, Rachel?
I've already explained to the judge that I had written in the original protective order that I figured it was you calling me. But when I got the records from the jail, I forget how many calls there were calls made from the jail from people I don't know, because I don't know anyone in jail besides you. But 6 different times calls were made from the jail to me. At least one of them was the one that used to message me on your behalf. I don't know who any of these people are, so obviously where did they get my phone number? Must have been from you.
Okay, next question.
So, I haven't called you, have I? Someone else in the jail has called you, but I haven't called you. Is this correct?
Correct.
Right. I haven't texted you. Someone else in the jail has texted you. This is correct, yes?
Correct, but you sent me requests so that you could call me.
Next question then.
What does Detective Jesus Evangelista say in his testimony in CR 2023-000379 that you are an highly experienced...
I'm not going to allow that. That's hearsay. Next.
It's not in.
Can I ask about the grand jury indictment?
Say it again, or repeat that?
Is grand jury indictment testimony hearsay as well?
I don't know.
You don't know.
I mean, no, it's not. I don't know. This is not a. I don't work in the legal field. I wouldn't know.
Do you know
I don't
any
even understand what you're
interviews between yourself and Sergeant Laura Leon and my interview at Sergeant Laura Leon had their audio tracks deleted, redacted, or completely removed?
It's not deleted or retracted. It's redacted to protect the victim. And at one point she said she had to stop the interview because it was too disturbing.
Next question.
Why does my testimony about your initiation into the Ordo Templi Orientis have to be redacted from a police interview?
Because it never really happened and you made it up afterwards when you wanted fuel to get Luke to go after me.
Next question.
Do you deny that you told me how you were initiated into the OTO, i.e. a 7-foot black-robed figure with a skull and horn mask with a serrated dagger pushed against the throat, and you told me that you were turned on by this?
Yes.
You do deny this?
Yes, that actually even makes absolutely no sense, because why would there be a crucifix in an OTO ritual, which is
Okay.
a Christian?
I never said
Anyway,
this.
it makes no
I never
sense.
said
Both of
this.
you stop. Next question.
Were you tied to some form of apparatus when you were initiated into the OTO?
No.
Not a crucifix.
No.
Next
And
question.
irrelevant.
Were you naked when the long-robed figure put the serrated dagger against your throat?
Oh my god. Irrelevant, absurd.
Well, it's not irrelevant because there's a clearly, you're telling me one thing, which is you like glorification of kidnapping, you like glorification of attempted murder.
Objection sustained. Next question.
So crazy. That's so crazy. I mean, how am I...
Do you think that you killed anyone in those hospitals where you worked, Rachel? Do you think that any of those people, all of those swabs, those remdesivir, those masks,
Objection,
those
irrelevant.
ventilators, had anything to do with all those people who were...
Do you have a question, sir? One question at a time, sir. You're not here to testify. Ask. Sir, be quiet when I'm talking. Do you understand me? Do you understand me? I'm waiting for an answer.
I hear what you're saying.
All right. Ask a question. One question at a time. Quit trying to testify while you're supposed to be asking questions.
Okay.
You may continue.
You worked as COVID testing in Sedona, didn't you?
Objection irrelevant.
Why is that relevant?
It says here that killed performing PCR tests while working at a COVID testing site during the pandemic, among other dangerous false claims. And I'm asking this question because I don't think that this is a dangerous false claim. I think this is a true claim, and I actually think that, you're culpable in a mass murder campaign, Rachel, quite frankly. And I
Do you have a question? Sir, do you have a question? Ask the
I do
question.
have a question. Do these people that you gave positive COVID test results to, were they moved to the COVID ward?
Objection irrelevant.
It's not irrelevant because you said killed performing PCR tests while working at COVID test sites during the pandemic, among other dangerous false claims.
Answer the question. Okay, answer the question.
I said that you said that, which you did, and no,
But you
the
did
people
work at
that I
Next
gave.
question, sir. Do not speak when she's speaking.
Sorry.
Next question.
People who were on the COVID wards, were they administered the drug remdesivir by Gilead Pharmaceuticals?
I don't know.
Then
Okay,
you
I
don't-
didn't even work in a COVID ward. I don't, objection irrelevant. This is like so crazy.
Again, I'd like to respectfully challenge the objection because people who were given remdesivir, 50% of them died.
It has nothing
and it
to
shut
do
down
with
their organs.
this.
It was a powerful RNA inhibitor.
Objection sustained. Don't talk while he's talking. Same rules apply to you. I understand you're frustrated. I understand that this is taxing. We have to do this the right way. Next question.
People who were given remdesivir, did you know that their lungs started filling with liquids, filling with water? Did you know this?
Objection irrelevant.
Sustained.
Did you know that these people who had liquid in going into their lungs, they were put onto ventilators and sedated? Did you know this, Rachel?
Objection irrelevant.
Sustained.
Did you know that the people who were put onto ventilators, a lot of them died, and they put COVID-19 related as the cause of death, even though there were other comorbidities? Did you know this, Rachel?
Objection irrelevant.
Sustained.
During the Nuremberg trials, did it matter if you were the man taking the Jew off the train or if you were trucking the Zyklon B into the gas chamber? Did you know that it didn't matter whether you were one or the other, you were still just as culpable, Rachel?
I can't even understand what you're saying, but objection irrelevant.
Sustained. Sir, if you need to ask a question that has to do with the issues that are here, none of these questions you're asking have anything to do with what we're here for.
You are claiming that I've sent people after you. How am I able to send people after you when I've been locked up in jail for the past 15 months?
Okay, so in exhibit C, here's one Adam final message. I'm being carted away after Rachel stole $500 off me. I think that was the rent that someone gave to me for him to pay. But anyway, it doesn't say that. It says after Rachel stole $500, she got me locked up. She lives at lot 32, Oak Creek Mobile Lodge. Someone go rescue the rig.
Okay, next question.
There's also,
You were paid $500 via Venmo that evening on December 14, 2022, were you not, Rachel?
yes, I asked you to pay rent and somebody paid it for you.
Do you think that Gail Rubin should also be charged with kidnapping and aggravated assault for practicing BDSM?
Calls for a legal conclusion. I'm not going to allow it. Next question.
Next one.
Sir, you have 3 minutes left.
Okay. Why do you think I was released with no complaint on December the 20th?
Because the interview wasn't properly filed on time. No one ever dropped your charges. Because the way the legal system works, you can't hold someone in jail, I think, for longer than 3 days without trial. And because the police had not finished filing the interview, they couldn't hold you there any longer and they couldn't take you to trial, so you were released, were asked not to go to my property, when the court would be continued at a later time, you were supposed to stay in the state, none of which you did.
Next question.
Do you think that the real reason that the interviews weren't handed in was because it was trying to cover up the existence of a child abuse cult that you are a member of?
I think that's insane, and no.
Then why were the interviews not handed in to the grand jury indictment on May the 4th?
They have all of the interviews.
They were not handed in on May the 4th.
You're testifying, ask the question.
Did you know that a motion to remand to the grand jury was filed by Gillian Marini on November the 8th, where clearly exculpatory evidence was not handed in by Detective Jesus Evangelista, i.e. your interview with Sergeant Laura Leon and my interview with Sergeant Laura Leon?
I can't really understand what you're saying, so I don't know.
Did you know that your interview with Sergeant Laura Leon and my interview with Sergeant Laura Leon was not handed in to the grand jury indictment on May the 4th by Detective Jesus Evangelista? And there was even a motion to remand to the grand jury complaining about the fact that clearly exculpatory evidence was withheld from the grand jury indictment. Were you aware of this, Rachel?
I know that the first interview I did after I was bound and beaten, my face was swollen up, I was bruised from head to toe, I was naked, found in a pile of urine when the police broke in the door. I was shaking so hard that the interview that I did, while I had asked her, please can you give me a blanket to cover myself up before you ask me any more questions, I know that that didn't count, that they needed to do another interview. So I doubt the first interview was used at the grand jury. As a victim, I don't have access to the grand jury case, but I would assume that first very scattered, after they took the bloody gag out of my mouth, I wasn't in much of a mood to talk. So I don't think that first interview was, but this is just speculation because I don't know, I wasn't there.
Okay, that answers the question, thank you.
Previous times that we have practiced BDSM together, when I had struck your buttocks with a blunt instrument, did I beat your ass or did I spank your ass?
Objection irrelevant.
Sustain.
When Billsy Bob practices spanking on you on camera...
Last question, sir.
Why is this not spanking? Why is this not beating? Why is this spanking?
Objection irrelevant.
Sustain. Cross-examination is complete. Sir, it's your turn to present your case. What would you like the court to know?
Okay, I've got a URL I'd like to read out.
Sir, you've got 5 minutes.
Okay, your URL is Hotel Tango Papa Sierra / Tango India November Yankee Uniform Romeo Lima Charlie Oscar Michael / uppercase Victor, uppercase Echo, uppercase Oscar, uppercase Hotel, uppercase Romeo, uppercase Charlie, lowercase Papa, lowercase Echo, lowercase Delta, lowercase Oscar, lowercase Sierra, uppercase Michael, lowercase Uniform, lowercase Sierra, lowercase Tango, uppercase Foxtrot, lowercase Alpha, lowercase Lima, lowercase Lima. That's tinyurl / VEOHRC, PDOS Master 4. This includes an interview by Luke McKee of Rachel Bulisky under the Telegram account Rachel Riot, where she admits that she has been a high-ranking member of the Ordo Templi Orientis, child abuse cult, and she has practiced something called Black Gnostic Catholic Mass, where she says that extreme sex is involved. And out ahead of the order of the Ordo Templi Orientis, Mr. David Stryven, aka Praetor Severius X, has admitted that 2 children are mandated to be in attendance. And there are photographs of 2 children wearing the same robes that OTO members wear at the Eugene Lodge in Oregon. There is hardcore sex involving anal sex, vaginal sex, oral sex. There is mandatory nudity involved, and this has been systematically suppressed and deleted of my own testimony and my own interview, where I had given testimony about my encounter with Rachel Bulisky in December the 14th. And now, before I'm even able to get to trial, having been locked up for 15 months, I have to then be accused of this with, something I can't fight back against. I'm chained up in here, I'm locked up in here. and Rachel's trying to get victim status. And she only started doing this after a Freedom of Information Act request after going to Sedona Police Department to ask questions about the 2 interviews, where Rachel's entire interview with Sergeant Lauren Leon had been completely deleted. And mine, there are 2 versions, first of all, and one of the versions is only 37 minutes long, the other one is in excess of 2 hours long, and both of which have got missing and redacted audio, where I gave testimony about the fact that Rachel and I have practiced BDSM on many, many occasions. I don't call it beating, I call it spanking. I don't call it kidnapping, I call it bondage. And Rachel even admitted in the information that I sent you with her own interview with Detective Jesus Evangelist of Sedona Police Department that she had been, was a submissive, and that being bound would typically be normal, was even testified in the grand jury testimony. However, Jesus Evangelista did not testify the discipline part, i.e. spanking, i.e. the striking of the buttocks with various blunt instruments, the sadism, i.e. the use of up to 100 milliamps electricity on Rachel. Rachel had encouraged me to use my devaccination as a sadistic torture method. And I have another link I would like to add to the court, please. Hotel Tango Tango Papa Sierra / Alpha Romeo Charlie Hotel India Victor Echo India Sierra / number 3 lowercase alpha lowercase Julia uppercase Papa number 6. And this is a review by the plaintiff Rachel Ann Bulisky called Kaleidoscope, Sex, Healing and Sadomasochism. And Rachel is singing this woman's praise, and Rachel knows full well that there is a very thin line between pain and pleasure, and she also knows that there's a very thin line between sadistic torture and medicine. In fact, Dr. Robert Young, who's also friends of one of the claimed victims that she's claiming against me, Dr. Ariana Love's ex-partners, has said that I'm the most honest doctor in the world by calling medicine by its true name, torture. And Rachel knows full well that torture, medicine, healing, sadomasochism, sex are all one and the same. Is it not torture when a woman gives birth to a child without having had sex? Yes, it is. All of these things are the byproduct of pain. Rachel and I have been involved with the whole infliction of pain and receiving of pain for months, since the end of September of 2022. And she consents to this, and she shook out my hand and said to me, having invited me up to her training, Unit 6 at the time, we later moved into Unit 32, that she would agree not to press charges, file any liens against me, or prosecute me in any way, shape or form. And I think that this is an act of filing liens against me, quite frankly. I also want to challenge the whole notion of, being choked. Now, not to grab the screen, but captive audience, that is Rachel Bulisky, and you can see that here is her, and she is being choked out whilst bound. So I want to know why Bill Zebon from New Jersey, who's just suddenly all of a sudden deleted 740 of his Twitch.tv account videos, is not also charged with kidnapping, aggravated assault, attempted murder, and Rachel doesn't have a protection order of protection against him. I have not contacted Rachel in any way, shape or form since February of 2023, and that's only when I started going through my belongings and realising that my gold spherical magnets worth $400 were not returned to my possession. My computer was not returned to my possession. My rife generator, worth $650, was not returned to my possession. My tripod, worth $70, was not returned to my possession. My 2 titanium bullet tweezers, worth $160, was not returned to my possession. My taser pulse, with my 9 rounds of taser rounds. I know it's only a taser, I know it's not classed as a firearm in the state of Arizona, but still, I have the right to keep and bear arms, and she has trampled my Second Amendment rights. I feel very upset about the fact that my taser was taken away from me. Yes, I have a penchant for putting electricity into people. No, I don't have a penchant for trying to kill people. And if you actually ask Rachel what's happened, and you look at the medical reports when she went to Yavapai County Regional Centre 2 days afterwards, the only thing that the doctor could find about wrong with her was a little bit of mild tenderness in the suprapubic region from the spanking. And if you're telling me that she practices BDSM and she's an extreme BDSM model, but she doesn't practice spanking, then, there's something seriously wrong with this woman's testimony. I honestly think that the credibility of the plaintiff is in doubt. I think that you should dismiss this. I will give you my word as an Englishman. I will never contact Rachel Bulisky ever again. I will never practice BDSM with her again. I will never have sex with Rachel Bulisky ever again. And I will never bring up her name. I will never breathe her name ever again. But this is just an excuse to try to cover up the fact that we have discovered 3 separate lies to try to cover this up. Lie number 1, that my file from J0301IA2022001420, where Rachel falsely claims charges were never dropped, when in actual fact we found that Mr. Grodsman just dropped all charges with no complaint.
Sir, you have 30 seconds.
Wait.
You have 30 seconds.
Ed Torres lied and said that they were falsely transferred, but this was false. Lie number 2,
They said that they only had the first appearance filed because Superior Court had it, but it's being kept on it as a paywall. And line number 3, the county's attorney file is claiming that they are notified the public defence officer of the case. That's wrong. The courts do it. There have been multiple lies that have been going on. We've caught them in the lies, and we're trying to expose this. And this order of protection is being used to try to mask the fact that she's not really a victim at all. She's a perpetrator. Thank you.
Thank you, sir. You have questions, ma'am?
No.
No questions then. Testimony is complete. Seems to me that at one point this was probably consensual, and there were some consensual things going on, but there did reach a point where things were no longer consensual, regardless of what was going on, and there came a point where the relationship was ended, and there were activities after the relationship that were certainly harassing, certainly would have disturbed the peace and quiet of the plaintiff. So I do find that the necessary relationship exists. I find that there have been acts, more likely than not, it's been proven, that there have been acts of domestic violence that have been perpetrated by the defendant. Therefore, the order shall remain in effect. We're adjourned.